despite.
So a promoter is a person who takes the steps to incorporate the company, and they can do it either under the Companies Act or they can do it under the IBC Act. And they also see to it that the shares and the loan capital, whatever is necessary for the formation of the company, they are responsible for setting all of that up. So there is no definition for the word promoter. But in the case of Whaley Britt versus Green, Judge Bowen said that the term promoter is a term not of law, but of business. Usually summed up in a single word, a number of business operations familiar to the commercial world by which a company is generally brought into existence. So that's all a promoter is, the person who brings the company into existence. And of course, he has to carry out other acts in the meantime in order to bring that company into existence.
Ms. Archer, sorry to interrupt, but who, okay, so normally speaking, let's say,
So
who would that person be?
Any individual could be
Oh.
I was just gonna say, would that be the lawyer? Would the lawyer be the promoter?
No,
Or even the CEO who would,
CEO could be the promoter,
yeah, okay, got it.
but he wouldn't be CEO at that time.
No, not at that time, no.
Right.
No, ma'am.
Or he could be the shareholder,
Right.
the shareholder. Or he could be the brother of one of them. Or he could just be a consultant that they decide to hire. And I take that back. It can't be a lawyer. It could be a lawyer whose firm does all of those services.
Incorporation, right?
Not just the incorporation in terms of filing the documents with the registrar. We're talking about more than that. We're talking about a person going out to select the building, to make arrangements for furniture, all of that. That's the promoter. He's going out and he's soliciting different contracts to get the business up and running. And that is a job that people carry out as a consultant. So the promoter is usually a person in a controlling position with regard to the company's affairs before it is formed and in its early stages of existence. So they're the one that goes about promoting and talking about this company that is coming into existence. So sometimes the promoter could be the person who drafts all the legal documents. They could be the one who nominate the directors, nominate the bankers. They arrange for the pricing of the shares. Like I said before, the purchase of the property. They do all of that. Now, in equity, and remember that equity means to be fair and just. So in equity, a promoter stands in what we call a fiduciary relationship towards the company. And that word fiduciary means that they have duties. So even though he may be a consultant, when he takes on that role as a promoter, automatically he has a fiduciary relationship towards the company that is about to come into existence. But he is not a trustee. In addition to that, a promoter cannot make a profit unless he discloses his interests in that transaction. And the company has to consent, or the group of persons to whom he is working for have to consent. Otherwise, he cannot profit from that transaction. So in the case of Gluckstein versus Barnes, it was held that a profit of £20,000 should have been disclosed and the appellant was bound to account to the liquidator for it. So in that case, in 1893, the National Agricultural Hall Company Limited owned a place of entertainment called the Olympia Company, which was being wound up. A syndicate was formed to raise funds to buy Olympia and then resell it, either to a company registered under the Companies Act for the purpose, or to another purchaser. If a company was formed, the appellant, Gluckstein, and the three other persons, Lyons, Hart, and Hartley, who were members of the syndicate, had agreed to become its first directors and to promote it. In the event a company was formed called the Olympia Company Limited, and the promoters issued a prospectus stating that the syndicate, which was promoting the company, had purchased Olympia for 140,000 pounds and was selling it to the company for 180,000 pounds, thus quite properly disclosing a profit of 40,000 pounds. What they did not disclose, but referred to vaguely as interim investments, was the fact that they had purchased certain mortgage debentures in the old Olympia Company for less than their face value, and that these mortgage debentures were to be redeemed at their face value out of the proceeds of the issue of shares. And this meant that the syndicate made a further 20,000 profit on the promotion. The company afterwards went into liquidation. Barnes became the liquidator, and he sought to recover the undisclosed secret profit. The following points of interest arise from this case. 1, there had been a disclosure by the promoters in regard to the 40,000 pounds and the 20,000 profit to themselves as directors. But of course, this was useless because disclosure must be to an independent board. The prospectus said that the 40,000 profit did not include profits on interim investments, but the court held that this was a disclosure of the profit of the 20,000 pounds. The case also illustrates that liability of promoters is joint and several for recovery of profit, because Mr. Gluckstein tried to defend himself by saying he was only liable for a proportion of the profits. And the House of Lords held him liable and account for it all, with a right of contribution against his fellow promoters. So a promoter himself, he can be liable for transactions, especially when it comes to property. So the liability of promoters as vendors of property may be considered under 2 headings. If he purchases the property before he began to act as a promoter, or he purchased it after he began to act as a promoter. So in the first instance, if he purchased the property before he began to act as a promoter, he doesn't disclose his interest in the sale, the company may rescind the contract. If the company wishes to keep the property, it may do so, but cannot recover the profit as such. So following the decisions in Jacques-Miller versus Marler, the remedy is to sue the promoter for damages and tort at common law for negligence if damage has been suffered. Actions may be brought against a promoter for fraud due to a promoter's misstatement. So for example, if the promoter acquired some land in 2010 for $10,000 and became the promoter of W Company in 2011, and he sells the land for $20,000 through a nominee and without disclosing his interests, then the company could either rescind the contract or they could keep the property and recover damages from the promoter for breach of duty of skill of care. And that breach of duty of skill of care is one of his fiduciary duties. Note that if the property was worth only $18,000 in 2011, the company could recover $2,000, but in those circumstances could it recover the $10,000 profit. Now, where the property is purchased by the promoter after he began to act as a promoter, the remedy again is rescission. But if the company wishes to doesn't want to rescind it, then it is possible to regard the promoter as an agent of the company when he purchased the property. And the company can recover the profit made by the promoter, because then he's acting as an agent. So he's acting on behalf of the company. Rescission is available if it is possible to restore the company and the promoter to the position they were in before the contract was made, as where the company has resold the property to a third party. In such a case, the company must go with the contract and sue the promoter for the profit made, depending on the promoter's position, which he bought the property and then later sold it to another company. So the duties of a promoter to the company are derived from common law. Because like I said, once you become a promoter in equity, he has a fiduciary duty. And that fiduciary duty is a common law position, which means that his duties arise by law. They are not contractual duties because the company is not incorporated as yet and cannot contract with the promoter. Nevertheless, a promoter can be regarded as a quasi-agent working without a contract, and as such would at common law owe a general duty in negligence to exercise reasonable skill and care in the promotion. So if he allows the company to buy property, including his own, for more than it is worth, he may be liable to the company for damages. And that'll all be because of he was negligent. So if a promoter issues a prospectus, which he knows to be false, so that the company is liable to be sued by subscribers, the company can sue him under common law for damages. In the case of Reed Leeds and Henley Theaters of Varieties Limited, the court proceeded on the basis of fraud. But since the company does not itself act upon the fraud by subscribing for shares, the decision is felt to be based on negligence. The purchase by a promoter of a business which loses money, the standard depends on the experience and the qualifications of the promoter in the business field. So that's another thing. If you wish to be a promoter and you turn around and you give advice and you make a recommendation, and the company then the company relies on that, buys this business, and then they lose money. Everything depends on whether or not that promoter had the experience and qualifications to make that decision. Again, because he has a fiduciary duty, it is expected that if you're making a recommendation, you have the requisite skills to do so. So duties are not owed to shareholders who are unable to bring a personal action unless this relates to false statements made by the promoter in a prospectus. Trade creditors and debenture holders cannot sue for breach of duty. For example, in Solomon, there was no action by trade creditors, although he did not disclose to them his interest in the promotion. The duties of disclosure and skill and care upon promoters do not end on the incorporation of the company, nor indeed on the appointment of a board of directors. However, once the company has acquired the property or business which it was formed to manage, the initial capital has been raised, and the board of directors has effectively taken over management from the promoters, the promoter's duties will terminate. Any questions so far? No questions on the promoter. So realizing all that has just been said, know that a company cannot make a valid contract before incorporation. A promoter cannot legally claim any remuneration for his services or an indemnity for the expenses incurred in floating the company. So in the case of Renational Motor Mail Coach, Clinton's claim, a company called the Motor Mail Coach Syndicate Limited promoted another company called the National Motor Mail Coach Company Limited to acquire the business of a motor mail contractor named Harris. The promoters paid out £416, 2 shillings, no pence, in promotion fees. The two companies were subsequently wound up, and Clinton, who was the liquidator of the syndicate, proved in the liquidation of the National Motor Mail Coach Limited for the promotion fees. The court held that Clinton's claim on behalf of the syndicate could not be allowed because the company was not in existence when the payments were made and could not have requested that they be made. The syndicate was not acting on the company's agent or at its request. And the fact that the company had obtained a benefit because the syndicate had performed its promotion duties was not enough. However, since the promoters or their nominees are likely to be the first directors, the payment will usually be made by the director under the general management powers. So as a consequence of a company having no legal existence and therefore no capacity to make contracts, is that if a promoter or some other person purporting to act as his agent makes a contract for the company before its incorporation, then the company when formed is not bound by it, even if it has taken some benefit under it. The company is unable to sue the third party on the agreement unless the promoter and the third party have given the company's right of action. Third, the company cannot ratify the agreement even after its incorporation unless the law permits. And fourthly, unless the agreement has been specifically to the contrary, it will take effect as one made personally by the promoter or other purported agent of the third party. So if we turn to section 22 of the CAC, I just gave you 4 points, which is the general supposition when it comes to pre-incorporation contracts. But let's look at what our law says. Section 22, subsection 1 says, except as provided in this section, a person who enters into a written contract in the name of or on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract. So the act itself tells you that if you go and you promote in your name, or you say you are doing this on behalf of ABC company, which is not incorporated, then you are personally bound by that contract. All the liability rests on you, and you're also entitled to all the benefits. Now, subsection 2 says, within a reasonable time after the company is incorporated, it may, by any action or conduct, signifying its intention to be bound, they can adopt a written contract entered into in its name or on its behalf before it was incorporated. So it's telling you that after the company is incorporated, the company can then pass a resolution to be bound by that contract. Subsection 3 says, when a company adopts a contract under subsection 2, A, the company is bound by the contract and is entitled to the benefits thereof as if the company had been in existence at the date of the contract and had been a party to it. So it's telling you that in a reasonable time after the company is incorporated, if the company decides that yes, they want to be bound by that contract, they can pass a resolution. And it says here, once they pass that resolution, it is as if the company had been in existence at the date of the contract. Because remember now, the date of the contract would have been prior to the incorporation. But under contract law, by passing of the resolution, they are saying that they are bound by the terms and conditions of that contract. B, a person who purported to act in the name of the company on its behalf ceases, except as provided in subsection 4, to be bound by or entitled to the benefits of the contract. So 4 says, except as provided in subsection 5, whether or not a written contract made before the incorporation of the company is adopted by the company, a party to the contract may apply to the court for an order under which obligations under the contract may be fixed or being joint or joint and several for apportioning liability between the company and a person who purported to act in the name of the company or on its behalf, and the court may make any order it thinks fit. So here it's telling you that the court does have the power to proportion liability for a contract that was made prior to the incorporation. Subsection 5 says, if it is expressly so provided in a written contract, a person who purported to act for or on behalf of a company before it was incorporated is not in any event bound by the contract or entitled to the benefits of the contract. And so all that is saying is that if you wish to be a promoter, you can actually enter into a contract which states that you are acting on behalf of the company, which is not incorporated, and that you are not liable. So that covers all of the precautions that a promoter can consider and what actions he needs to take in order to protect himself from liability. So pre-incorporation contract solutions to promoters' liability. A promoter may overcome difficulties with pre-incorporation contracts. He could incorporate the company before he makes contracts, in which case the problems relating to pre-incorporation contracts do not apply. He can settle a draft agreement with the other party so that when the company is formed, it enters into a contract on the terms of the draft. The articles of the company can be drafted to include a provision binding the directors to adopt it. The promoter is never liable here because there's a contract with him. But that's another way that he could try to reduce his liability. The promoter may make a contract himself and assign the benefit of it to the company after it is incorporated. So here the promoter remains personally liable for the performance of his promises in the contract after the assignment to the company. And therefore it is desirable for the other party to the contract to agree that the promoters shall be released from their obligations if the company enters into a new contract with the other party after incorporation. Since the promoter will usually control the company at this stage, they should be able to ensure that the company does make such a contract with the other party and so procure their own release from liability. So where the promoter is buying property for the company, he may take an option on it for say 3 months. If the company, when it is formed, wishes to take the property, the promoter can assign the benefit of the option to the company to enforce the option personally for the company's benefit. If the company does not wish to take the property, the promoter is not personally liable to take and pay for it. Though he may lose the money he agreed to pay for the option. But whatever you do as a promoter, be mindful that the Companies Act does provide for ratification of pre-incorporation contract by the company after it is formed. Any questions on pre-incorporation?
I have a question, not specific to pre-incorporation, but well, yes. Okay, so most promoters, I'm sure they would be oblivious of all of these stipulations. So what exactly are they guided by? I mean,
That's a good question because this have my head spinning.
I can't, because I'm trying to think of our company when it first started, and I know the individuals were not or would not have been, you know, this is heavy. So what are they
I feel
guided
like
by?
I'm in law school.
But see, this is the thing. Before I answer, or just leading to your answer, see, you have to be mindful when you take on certain job. You have to know the law that's related to what you do. So let's look at this promoter now. Let's just say we had all decided in this class we're going to open a restaurant.
Right.
And you decide now, Angelique, that you're going to go and look for the building. You're going to go and see what equipment we need. You'd speak to the company, who you're going to order it from. You're going to order the chairs. You're going to arrange with the electrician to set it up. We know how we want it petitioned off. You're going to talk about the town planning, about the parking and what's the best way to put the gate. You're going to do all of that. So you are the promoter. So as far as you're concerned, you just going about trying to put this together for the shareholders.
Correct.
In your mind, you're not even thinking that, oh, hold on now. I'm doing all of this on behalf of a company that we have to form. Now, when I do all of these things before, unless someone turns around and sues you, you will continue to do that, especially if you were good at it for the first one. Because as far as you're concerned, you guess what? Someone needs to put something together to start a business. I can do it. I did that one with ease, not realizing that there is liability involved because the company is not incorporated as yet. And when you do these things, you are personally liable unless you enter into a contract. And then it has to be adopted by the company. So you move from just being a businessman, seeking to find a building and furniture and getting approvals, to being a person who is actually in law, acting on behalf of a company that is not incorporated as yet. So unless you have a written contract that states it's going to be adopted after the company is incorporated, then you find yourself being personally liable. Now, if all of us are in this with you and we're consulting and going back and forth and talking and making decisions together, then what Angelique can do is she can go before the court if she is sued. She will be the primary person liable, but liability will be joint and several. So that means that all of us will have to contribute towards whatever damages are incurred if there's a breach of contract. So in law, everything has a place. So you're talking about company, it's company law or IBC. But within that realm, you have contract law. Law is always a good, I guess, subject to read, because then you begin to understand more how things operate in the world.
Oh, boy.
What happened now? Speak.
No, I just got to read this chapter over again. Definitely.
Pre-incorporation,
Mhm. No, I mean,
talking
the,
about ability.
mhm.
Because remember now, when we started over with
Sure,
go ahead.
Archer, I'm sure persons who take on this role, I mean, I'm trying to be funny when I say this, but I mean, when you hear the word the promoter, the first thing that comes to my mind is, I mean, in our generation, someone who just promoting the business and letting people know, okay, this is what's coming, this is what you need to expect, basically just getting the word out that this is an up and coming like business.
Mm-hmm.
But clearly it's more implications for this.
Mm-hmm. Especially if it's not incorporated.
Very much so.
So a lot of people do that. They have a business that's incorporated in another jurisdiction. They want to incorporate a subsidiary here or an affiliate, and they go about promoting that company. And there is liability involved. So they have to make sure that they have a written contract and one that says that the company will adopt it once it is incorporated.
Mm.
But I mean, be mindful that that is why we have law. It's the same way, like if you get married, then what happens? There's a law that covers that.
Miss Archer, that ain't a good. I don't think that one good because these people in lawless, these married people lawless. So I know if that's a good, that's a good comparison.
It might be a good analogy, Angelique, but the thing is, in both scenarios, you don't know until the problem has occurred. You don't.
Exactly. You understand?
Exactly. No, I use that as an analogy because in some of the other classes where I teach, when we get to certain topics and I explain to them what the law is, the students don't say, "Oh, I ain't getting married." No, not doing that. No, especially when they start we're talking about investments, and then I say, well, so I think the last class I had, one of the students had some property. I think she had property. And she was saying, now, if I got married today and I were to die, well, what happened to my property? I said, did you write a will or you didn't write one? So she said, no, I have not written a will. I said, well, you'll get all of it. Man, listen here. She almost died. She said, oh, no. She said, where you getting that from? And I had to pull up the legislation and read it. Oh, she said, oh, no. Not happening.
Well, that one is an easy fix. Just write a will. Like,
Yeah,
that's so
you're right.
easy.
Yeah.
But we take that very lightly in this country, I believe.
Mm-hmm.
Writing wills or whatever.
Yeah. They don't like to do it until depends on the classes you take and you begin to realize what will happen. Yeah. You start to consider these are things that I need to do. Yeah, but in law, there's a lot of liability, a lot of things you need to be aware of.
Yes, I agreed.
It's just a lot. All right, so for incorporation, whether it's an IBC or a CAC, you have a certificate of incorporation. And remember in the Solomon case, that certificate of incorporation is when that company is authorized to do business. All it means is that the company has complied with the requirements under the legislation. Then you have the memorandum and you have the articles of association. And the memorandum just gives you the name, the type of company, the registered office name, address, the objects, the limitation of liability, capital, the shares, and the subscriber's name. So let's go to the CAC. And I think I have my IBC crew too, right? So what does the CAC say about the memorandum?
Miss Archer, you know what I wanted to ask you whilst we touching on the memorandum and the articles of association.
Mhm.
The memorandum and the articles of association, would you say are 2-in-1 document?
What do you mean 2-in-1?
Because a lot of times, like even when I do reviews, okay, like sometimes the same information that's in the memorandum, but the memorandum can serve the same purpose as the articles of association. You don't think so?
They're
No.
usually separate.
I just wanted to ask that.
Yeah, they're separate. They're two
Mhm.
different documents.
Mhm.
Two different documents.
And I think just to elaborate on her question, and they always serve very distinct
And
purposes, right?
Mhm.
Yes.
Okay. So there should be no overlap in
No, there's no
the
overlap.
provisions of each document.
Right, the articles is your document to go to as to how to run the company. And it also sets out the powers. So that's your source document. So say you were going to write a resolution, say you were going to make an appointment, or you are going to have a meeting, you go to the articles. So let's go to, who's going to do the IBC?
I think Sharella and I
Yes, that's us.
signed up for that.
Right.
Yeah.
So what do we?
I think that's section 13. We're just reading the provisions of,
Yes, just the provisions.
okay, and that's for, we're starting with the memorandum.
I want you to understand. So someone do the memorandum for the IBC and then the memorandum requirements under the CAC.
Okay,
Sandy, you want to start?
sure, I'll go.
Okay.
And so this is the IBC.
Right.
This provision is under section 13 of IBC.
Mm-hmm.
Okay.
Subsection 1, the memorandum shall include the following particulars. 1A, the name of the company. B, the location in the Bahamas of the registered office of the company. C, the location in the Bahamas of the registered agent of the company. D, subject to subsection 2, the objects or purposes for which the company is to be incorporated. E, the currency in which shares in the company shall be issued. I said E, yes. F, sorry, in the case of a company limited by shares, a statement of the authorized capital of the company setting forth the aggregate of the par value, if any, that the company is authorized to issue, and the amount, if any, to be represented by shares without par value that the company is authorized to issue. G, in the case of a company limited by guarantee, a statement that each member undertakes to contribute to the assets of the company in the event of a winding up during the time that he is a member or within 1 year afterwards for payment of the debts and liabilities of the company contracted before the time at which he ceases to be a member, and of the costs, charges, and expenses of winding up the company, and for the adjustment of the rights of the contributories amongst themselves, such amounts as may be required, not exceeding an amount to be specified herein. H, and of course, there are sections that define each of those references, like contributories, winding up, etc. That would make those provisions I just read clearer.
Mhm.
And so H, in the case of a company limited both by shares and by guarantee, the statements referred to in paragraphs F and G. Section I, in the case of an unlimited liability company, a statement that the liability of the members is unlimited. J, a statement of the number of classes and series of shares, the numbers of shares of each such class and series, and the par value of shares with par value, and that the shares may be without par value if this is the case. A statement K, a statement of the designations, powers, preferences, and rights, and the qualifications, limitations, or restrictions of each class and series of shares that the company is authorized to issue, unless the directors are to be authorized to fix any such designations, powers, preferences, rights, qualifications, and in that case, an express grant of such authority as may be desired to grant to the directors to fix by resolution any such designations, powers, preferences, rights, qualifications, limitations, and restrictions that have not been fixed by the memorandum. That's a lot.
Yeah, that's a lot. But but in a nutshell, all is really telling you is the name of the company, registered office, the shares, the objects, what it's going to do for business, who to subscribe. That's roughly it in summary.
Right.
Yeah, that's all.
And
That's all.
that's what subsection explains, what you just
Yeah, that's about it.
subsection 2.
And then you just state whether or not the company is by shares or by guarantee or by shares and guarantee. So if we go to the CAC, what does the CAC says? Where are my CAC people?
You're like, holla.
Yeah, let's go. CAC, start with section 5.
Okay, subject to section 13, where a company is incorporated on the principle of having the liability of its members limited to the amount unpaid on their shares hereinafter referred to as a company limited by shares, the memorandum shall state the name of the proposed company with the addition of the word limited or LTD as the last word in such name, the location in the Bahamas of the registered office, that the liability of the members is limited, the amount of capital with which the company proposes to be registered, and subject to section 35 and 3, its division into a stated number of shares of a certain fixed amount, and no subscriber may take less than 1 share, that each subscriber to the memorandum shall write opposite his name the number of shares he takes and the number of shareholders, the amount of share capital as indicated by the number of shares, and the value of each share with which the company proposes to be registered. That's section 5, A through G.
And then section 6 speaks to unlimited liability.
Yeah, and then section 7 speaks to companies limited by guarantee. You want me to read all that? Because
No.
everything, okay, because they speak just about the same thing as to the company limited by shares.
Yes, it's the same requirement, more or less. The name of the
Uh-huh.
proposed company, location of the registered office, and then you have to state the capital.
Yes, ma'am.
And when they say location of the registered office, they've amended that to say you have to state the street address and postal address. It's not just location now, it's street
Okay.
address and postal address.
And post office. Okay, all right then.
Yeah. And then, of course, you can have a company limited by shares and by guarantee.
Okay.
And then it says in section 9, the memorandum shall be signed by each subscriber in the presence of at least one witness who shall attest his signature. The memorandum shall, when registered, bind the company and the shareholders to the same extent as if each shareholder had subscribed his name and affixed a seal thereto. And B, there were contained in the memorandum on the part of himself, his heirs, executors, and administrators, a covenant to observe all the conditions of such memorandum subject to this act. And 3, subsection 3 says where a company referred to in section 5, 6, 7, or 8 increases the number of its shareholders or members or the amount of its share capital beyond the registered number or amount as contained in the memorandum, notification of the increase shall be given to the registrar within 14 days of the resolution authorizing the increase, and the registrar shall thereupon record the increase. So that's the memorandum. So it's roughly the same. And it says under the IBC Act that a company may amend its memorandum to change its name. And where the company is incorporated under that name, under a name that is identical with the name under which a company in existence was incorporated under this act or registered under the Companies Act, or it resembles another company name, the registrar may, with or not the consent of the company in existence, give notice to the last registered company to change its name. And if it fails to do so within 60 days, the registrar shall direct the company to change its name to such name as the registrar deems appropriate. So what does the CAC say about name? Can you use any name?
For section 12, it says, no company shall be incorporated under this act under a name that is identical with that under which an existing company is already incorporated under the former act or any other act concerned with the incorporation of companies or which so nearly resembles such other name as to be calculated to deceive or confuse, except where the company in existence is in the course of being dissolved or signifies its consent in such manner as the registrar approves. B, contains without express prior permission of the registrar, which permission may be withheld without assigning a reason the words assurance, bank, building society, chamber of commerce, chartered, cooperative, imperial, insurance, royal, or word conveying a similar meaning, or any word that, in the opinion of the registrar, suggests as it is calculated to suggest. You want me to read all that?
No.
All right.
No.
And then they say C is indecent, offensive, or in the opinion of the registrar is otherwise objectable.
All right, and then it says that the subsection 2 is similar to the one I just read for the IBC Act, where their name is similar or identical, where the registrar will give you notice, and then you have 60 days if you fail to do so, and then they could just change the company name to whatever name that they deem to be appropriate. So subsection 4 says, no, 3 says a company may amend its memorandum to change its name, similar to the IBC Act. Subsection 4 says, subject to subsections 1 and 2, where a company changes its name, the registrar shall enter the new name in the register of companies in place of the former name and shall issue a new certificate of incorporation indicating the change of name. And a change of name should not affect any rights or obligation of the company or render defective any legal proceedings by or against the company. And all legal proceedings that have been commenced by or against the company in its former name may be continued in its new name. And this really becomes difficult for when you have IBCs that change their name every 2 to 3 years as they change beneficial owners. They keep changing the names. So now let's look and see what the articles are all about. The Articles of Association. Let's start with the CAC, Section 10. What are the articles?
Okay. Subject to subsection 2, articles signed by the subscriber to the memorandum shall be filed with the registrar in respect of each company not later than 6 months after the issue of the certificate of incorporation of the company. A company limited by shares may, instead of filing articles, notify the registrar in writing at the time of submission of its memorandum that it adopts the first schedule either with or without modification. Modifications to the first schedule shall be filed with the registrar. And then 4, a company limited by shares which does not file articles within 6 months from the date of filing its memorandum shall be deemed to have adopted the first schedule.
Mhm.
To continue.
And what's the effect, signature and effect of articles?
And then the articles, when registered, bind the company and the members thereof to the same extent as if each member had subscribed his name and affixed his seal thereto. And there were contained in such articles a covenant on the part of himself, his heirs, executors, and administrators to conform to all the regulations contained in such articles subject to this act, and all monies payable by any member to the company in pursuance of the conditions or regulations shall be deemed to be debt due from such member of the company.
Okay, so what exactly are the articles? What are they?
Are they the guidelines of how the company is to be run?
Yes. So I don't have the copy you have. Look to the back of your company CAC Act. Look for the first schedule. It should be at the very back. You see where it says under section 10, subsection 2, where it says a company limited by shares may, instead of filing articles, notify the registrar in writing that it intends to adopt the first schedule, either with or without modification. And then any modification are to be filed with the registrar. But at the back of the CAC, in the first schedule, is the Articles of Association. So normally you will have companies, they write their own, or the lawyer would write their own. But the act does give you the option to just adopt this first schedule as is. Found it? Just go to the end after
I see it.
304. It says articles of association of a company limited by shares. No, yes?
Got it.
Okay,
Okay,
good,
thank you.
right. And so you see it has business.
On my handout, sorry, my printout, it's 108. I don't know if that'll help
Yeah,
Yeah,
oh,
that's good.
everyone.
mhm.
Okay,
So the director shall have regard to the restrictions on the commencement of business imposed by section 42 of the Companies Act, if and so far as those restrictions are relevant to the company. So you see why even when you become a company secretary, you need to have your Companies Act handy. Because even in carrying out the provisions under the articles, you still have to refer to the act. And section 42 speaks to the restriction on the commencement of business. So it says a company shall not commence business or exercise any borrowing powers unless shares held subject to the payment of the whole amount thereof in cash have been allotted to an amount not less in the whole than the minimum subscription. So which means that before you could commence business, the shares have to already been issued at the minimum amount. Every director of the company has paid to the company on each of the shares taken or contracted to be taken by him and for which he is liable to pay in cash, a proportion equal to the proportion payable on application allotment on the shares offered for public subscription. And section C says, there has been filed with the registrar a statutory declaration by the secretary or one of directors in the approved form that the condition specified in section 40 have been complied with. And section 40 speaks to the restrictions as to allotment. And it states the conditions. This speaks to no allotment can be made unless it follows the conditions that have been fixed in the memorandum and the article or the articles or in the prospectus that was issued. And if no amount was fixed or named, then the whole amount of the share capital so offered for subscription. So normally when the articles itself is silent on a particular matter, reference is made to this first schedule. This more or less gives you the template on how the company should be run and who has the powers to do certain things. Now in the IBC Act, the articles, again, is just as short as in the CAC Act. It just says the articles shall be subscribed to by two persons in the presence of another who shall sign his name as a witness. And such articles shall be filed with the registrar on the same date as the filing of the memorandum. So is that a requirement under the CAC? It's not, right? Because under Article 10 of the CAC says that the articles signed by the subscribers to the memorandum shall be filed with the registrar in respect of each company not later than 6 months after the issue of the certificate of incorporation. Whereas under the IBC Act, they're done together. So we understand the difference between the memorandum and the articles. Yes?
Yes, ma'am.
Yes.
Mhm. So the articles would speak about the shares, the transmission of shares, the meetings, the voting rights and proxies, the appointment, resignation, removal of directors, the powers of directors, the management of the company, the seal, the authentication of documents, accounts, indemnification, audit, winding up. All of that is included in the Articles of Association. So the certificate of incorporation under the IBC is section 16. What does it say?
Okay, that's me. Okay. Where the registrar issues a certificate of incorporation of a company, the company is from the date shown on the certificate of incorporation, a body corporate under the name contained in the memorandum with the full capacity of an individual who is sui juris, subject to any limitations imposed by the memorandum and to the provisions of this act. And I think it's easy to just remember, it's like the birth certificate, like how we have passports, individual people have passports and birth certificates. That's the purpose it serves, right?
Yes.
Okay.
And under the CAC, section 16. Where my CAC crew?
You want me to read it?
Go ahead.
Okay, upon receipt of a memorandum in conformity with the requirements of this act, the registrar shall issue a certificate of incorporation in the approved form, and such a certificate shall be conclusive proof of the incorporation of the company named in the certificate. From the date of incorporation mentioned in the certificate, the subscribers to the memorandum, together with such other persons as may from time to time become members of the company, shall be a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company and having perpetual succession and a common seal, with power to hold lands, but with liability on the part the members to contribute to the assets of a company in the event of its being wound up. A copy of a memorandum or articles filed and registered in accordance with this act, or any extract therefrom, certified under the hand and the seal of the registrar as a true copy, shall be received in evidence in any court in the Bahamas without further proof.
So you have the articles, you have the memorandum, and then you have the certificate of incorporation. Now, a company can amend its memorandum or articles. So under the IBC Act, section 18, it speaks to the amendment of the memorandum or the articles. IBC? Where my IBC people? Isn't that Sandy?
Must be falling asleep.
No, Mom, we here,
Um,
we here, we here, we here.
Of the memorandum or articles.
Okay, amendment of memorandum or articles, section 18, subsection 1. Subject to any limitation in its memorandum or articles, a company may amend its memorandum or articles by a resolution of members, or where permitted by its memorandum or articles, or by this act, by a resolution of directors. And subsection 2, a company that amends its memorandum or articles shall submit to the registrar within 28 days after any amendment a copy of the resolution of members or directors amending the memorandum or articles, as the case may be, authenticated in accordance with subsection 1 of section 73 as a true copy of the resolution amending the memorandum or articles, and the registrar shall retain the register such copy shall retain and register, such copy of the resolution. And subsection 3, an amendment to the memorandum or articles shall not have effect until it is registered by the registrar.
Okay, so under the CAC, alteration of memorandum and articles. Section 29.
Section 29(1), subject to this act, a company may by resolution of the members alter the contents of its memorandum. Subject to this act and to any conditions contained in its memorandum, a company may by resolution of its members alter or add to its articles. A company that alters its memorandum under section 1 or alters or adds to its articles under subsection 2 shall submit to the registrar a copy of the resolution of members altering its memorandum or altering or adding to its articles, as the case may be, signed by a director, the secretary, or an authorized officer of the company as a true copy of such resolution, and the registrar shall retain and register such copy of the resolution.
Okay, so is there any difference in altering your memorandum or articles under either act?
Resolution, no, it's pretty much the same process, right?
Same process,
Mhm.
yes.
Is
So
there a
in-
sorry,
Go ahead.
is there a checklist or do you have access to like say you're onboarding corporate clients? Is there a checklist of, start mandatory docs or, just a nice straightforward checklist of what you should or must accept versus, what's nice to have? So what's needed to have versus what's nice to have?
You mean for incorporation?
Yeah, like if you're onboarding a company. No, like the KYC docs, the memorandum, the certificate of incorporation. Does it have to be, so I think okay, so do the documents have to be certified if they're not the original? I know we always say stipulate certified copies. But, in this fintech space, a lot of people aren't getting the documents notarized or certified.
Okay, so if you're in the fintech space, then you have to go to the securities
Mhm.
AML guidelines or the
Okay.
securities AML rules.
Okay.
If you're under banking, then you would go under the central banks,
Guidelines.
yes, which
Yeah.
requires them to be certified.
Mhm. Yes, ma'am.
So you have to go under the securities rules for
Okay.
AML,
Okay,
and they'll tell you what needs to be certified.
thank you.
Mm-hmm. But whenever you're dealing with a company, I know a lot of persons who are in management or even directors.
Mhm.
They seem not to understand the role of compliance when it comes to reviewing a company. They believe that compliance is just responsible for KYC, just the
Yeah.
passport and the address verification.
Mhm.
And they don't understand as much more. Because even though you
Now,
may
Ms. Otto?
So even though you may have, let's say if you're under
Why,
a,
hello.
yes. What you going to say?
I listening to you.
Oh,
Thought us out.
Don't lose
So-
your thought. Don't lose your train of thought, Ms. Acho.
So even though you may be under the SP arrangement, the SP does the maintenance of those files, still as a compliance officer to the examiners or the regulators, you have a responsibility as the compliance officer to make sure that those files have on it the memorandum,
Mhm.
articles of association,
Mhm.
any amendments thereto,
Mhm.
certificate of incorporation,
Mhm.
any name changes.
Mhm.
Then you move on to whether or not you have the ultimate BO,
Yep.
the ID of that ultimate BO, the ID of all the directors. You have the authorized signatory list, the ID for those authorized signatures. You have an organizational chart, especially if it is complex.
Mhm.
Then you need to see whether or not at the very top, is there a trust? If there is a trust, you have to have the trust deed, or you have to have a declaration from the trustee that they will provide it when it is requested.
Okay,
You
see
need-
that, sorry,
You see that a lot.
yes, ma'am.
And then you need all the IDs of all the beneficiaries to settle law, to protect them.
Jesus, Lord.
Okay, so see there, Angela, you probably could use that checklist as well, sound like.
I just gonna, can I get that? Miss
I
Audrey,
just get out my head. You want me to send it in an email?
Yes,
I
ma'am, please.
really
Thank
would
you.
appreciate if you could send me that in the email.
Because
Yeah.
I find that I'm gonna have to do a training so that higher up can understand and see everything that's involved with onboarding. You can't just, it's not a check the box process, and trying to explain that is very,
Literally, and that's something what I can, and that's something what I could pass on to the account officers, because in commercial banking, you know, the account opening officers are literally the first point of contact for these
Yep.
persons. So that would definitely be a good training for them,
yeah.
because they just literally, we have a checklist of the documents that you need for an incorporated company. So once they see, once they there, they ain't gonna pass nothing extra.
And that means when it comes to you, you're getting trash. So you have to
Exactly.
take
So
away
when
the
it comes to
time.
me now, I gotta take my time,
Mhm,
put together the whole pot of stew,
mhm.
and then have headache for me.
Yeah.
Yeah.
So you
Because-
know, it's easy.
Don't forget now, when they on board, they're only looking, like you said, a check the box is only for
Mhm.
documents.
Correct.
But when you get it, you have to see whether or not the purpose for which they want the product that they're seeking makes sense.
Correct. Correct.
And then add to that, you have to see whether or not what you have before you and whether or not the purpose is within the law.
Correct. Very much so.
So you need to know a little bit about the compliance side of it. You got to
Mhm.
know a little bit about company law. You have to know
I
a
just
little
thought.
bit
Mhm.
that. You have to know a little bit about contracts, how they work. So it's a little bit of everything as you go around and around. And that's why you're constantly in school.
Yeah.
Yeah. Oh Lord, I tired.
You have to learn a lot.
Yeah.
Mhm.
You have to learn a lot. So let me ask the question now. Why is a registered office necessary?
A registered, well,
Office.
from a compliance level.
No, from a company standpoint, why do companies need a registered office?
To be in my experience, some of the accounts that we onboard, and I know this is not the answer that you're looking for, but I know in our case,
I know.
in a lot, in a lot of cases, they're really just I know different jurisdictions have a different name for it, but some of them are just holding companies or domiciliary companies with no physical presence. So the registered office serves as that, I guess, point of contact address. Yeah, because you know, essentially you wouldn't have a real physical address for that particular company.
Yes, more or less.
I told you.
Yeah, but I mean, that's really what it is. Under the
Mhm.
IBC Act, it says a company should at all times have a registered office in the Bahamas.
Mhm.
And that address has to be with the registrar. And that's why you see when a company transfers from one registered office to another one,
Mhm.
there's always a lag in between. And that's when a lot of things fall through the cracks. Because sometimes the outgoing doesn't send the advisement to the registrar.
Mhm.
And then the incoming is sitting waiting on the files to be sent to them in order to take on that responsibility. And sometimes time passes and it never happens.
Mhm.
So what's the registered agent role?
You're right. Isn't a registered agent? And
They certify the documents.
yeah, I just want to say certify and incorporate the company.
To prepare the documents.
What documents? What you
Correct.
mean?
The
Representative
incorporation of the
details
company.
the registrar, the memorandums and articles.
Uh-huh. That's it?
It's the minutes of the meeting.
That's all they do?
Most of the times isn't the registered office, the person that, the law firm that incorporates the company?
Yes, they can be the registered office, but what's the role of the registered agent? What does that registered agent do?
I don't know.
I mean, I know you hear people saying, registered office and registered agent.
Yeah, but I think they deal with, like, when it comes to all the documentation and, I mean, that's what
Would they not be, is that the person that receives, I guess.
Yes. I think you're trying to find it. Let's go. What is it? What is the rate?
We don't feel bad,
I guess
Mrs.
to
Archer.
receive. Well,
I asked this question at work, Angelique, so don't feel bad, and I still haven't gotten a definitive answer.
No?
No, I was told one is the physical address and one is the, like, the persons, which I think we're all, those who have offered an explanation have been saying. One is the physical address, and one is sort of like the persons that do the actual whatever filings.
And I feel like they probably are responsible for like disseminating any like legal action. I mean, like, what the word is, what I probably informing on any legal like notices, annual reports, that.
Yeah. So the role of the registered agent is they are responsible for ensuring that all of the statutory filings are done on time.
Oh.
So
Oh,
they-
company related, yeah, company
Yeah.
law related, okay.
Yeah, they would prepare the annual statements, the
Mhm.
annual returns. They would do the filing for
Which
FATCA. Go ahead.
which all of this with the, I mean, well, I mean, I see, well, dealing with the corporate accounts, you see why that would tie hand in hand with the law firm that incorporate the company. The law firm would be the registered office. It would be the legal agent, right? So I'm guessing this is why most of the times companies that are incorporated list their law firm as all of these things.
Yeah. Now, remember now, to provide that service as a registered agent, you need to have an FCSP license.
Mhm.
Yeah, I was about to say, and to her point, a lot of the law firms would have a corporate entity
Yes,
typically for that, for those purposes, which is separate and apart from the law firm itself.
exactly. Because they're providing a service. And then they would also draft the resolutions. Let's just say they decided that they're going to change directors. They would advise that they're changing directors, and the registered agent would prepare a draft resolution for their signature. So they work hand in hand, the FCSP and the legal firm. So let's just say that the shareholders of that company want to enter into a business contract, and they're going to use that company. Then the first thing the lawyers are going to try to find out is whether or not that company is in good standing. And so that's where the registered agent comes in, because the registered agent has to confirm that that company is in good standing, which means all his filings have been done for the year. And then
Okay.
added to that would be whether all of his KYC has been done. Then the lawyers would actually request that file, because then they have to review the memo and arts, and any amendments before they decide whether or not the company can actually transact in that business. So they go hand in hand.
So Ms. Archer, technically the registered agent, one of their functions is also reporting FATCA and CRS?
Some of them do, yes.
See, so what ours doing?
So
Okay.
now you understand why they must have a license, because yeah, reporting FATCA and CRS, I don't walk in the park. Well,
But remember,
Yeah.
FATCA is more transaction oriented.
Mhm,
So unless you
yeah,
have
yeah,
some, then it will be a nil report, but you still have to report.
mhm.
correct. And then, they have portals which you report those in, so.
Right. So you still have to report no matter what.
Sound
So
like
the-
I need to go, sound like I need to go to one of these law firms looking for a compliance officer. Hey.
I thought you like it where you are.
Everyone complains. Every class I've been in, we had a representative from BOP. It's so funny. I'm
I
sorry.
don't know why she's complaining.
Hmm.
A place to work,
Stop it, Miss Archer. Stop.
job security.
Well, yes.
It's job security. It's a wonderful place to work. All right. So let me talk about altering the articles.
Okay.
So articles can be amended by special resolution. And we know that the revised articles have to be sent to the registrar. So in the case of Green Hog versus Arden Cinemas, Master of the Rolls Evershad said, when a man comes into a company, he is not entitled to assume that the articles will always remain in a particular form, end quote. The company represents a separate legal entity whose existence will, in most instances, extend far beyond either the involvement or life expectancy of the current members. As such, the company is subject to specific decision-making processes that enable it to respond to its environment and to update its constitution accordingly. In the case of Russell versus Northern Bank, the House of Lords stated that, quote, a provision in a company's articles which restricts its statutory power to alter those articles is invalid. Any contract by a company which purports to agree that its articles will not be amended in the future will not be enforced by the courts. Now, the process of amendment is always subject to the principle of majority rule. So how is this process governed? So as to ensure that the majority may not take advantage of their position to the detriment of a minority within the company. One, there should be a provision that the members will not be bound by an alteration of the articles if it requires him to subscribe for more shares than the number currently held. Two, even though the general rule is that a company cannot restrict its power to amend its articles, what some members do is they entrench provisions within the company articles. That is, the articles may contain provisions which may be amended or repealed only if certain conditions are met or procedures completed. With that are more restrictive than those applicable in the case of a special resolution. Like, for example, you could have the consent of a particular member of the attainment of a higher percentage of the members in a general meeting than that required for a special resolution. Entrenched provisions may be amended subject to the agreement of all members of the company, or it can be done by the court. As stated in the case of Allen versus Gold Reefs and West Africa, there is the suggestion that members must exercise their votes bona fide for the benefit of the company as a whole. And this suggests that the court has jurisdiction to regard an alteration of the articles as invalid unless it is made for the benefit of the company as a whole. So what the court does is it looks to see the company's equilibrium. That is, that the members will vote independently of each other and not as if they were combined to coerce other members. And this is known as the objective test. Now, you can have a breach of contract that arose out of an alteration of the articles. So what I'm saying is that a company cannot, by altering its articles, escape liability for breach of contract. In the case of Southern Foundries versus Shaw, the court gave support to the view that the other party to the contract can sue the company for damages only and cannot obtain an injunction to prevent the alteration from taking effect. So yes, the company can alter its memo and arts, but it cannot avoid liability for breach of contract. Any questions? No?
No, ma'am.
So now I could send you all another question now, right?
No, ma'am.
Yes. Yes, I'm going to send another question. I'm going to send another one. As you'll see that once you finish with the Solomon principle and piercing the corporate veil, then we look at actual questions related to company itself and how companies operate.
Okay.
So I have a question for you all now. Just give me 1 second because I wrote it down. And it has to do, why didn't I type it? All right, so what if I ask you? Describe the procedure for the alteration of articles and state the considerations made in determining the validity of the alteration.
Mhm. Resolution. Majority and resolution.
Any other consideration?
May I phone a friend?
Yes. Which one you phone in? Angelique?
Anyone.
Hilarious. Don't phone Sandy.
Or Sandy A?
I love it. I just love it. No, Sandy can't help her.
Okay, we know it's special resolution. We know it's majority rule. What other consideration? Was the last, just about before, the last thing I said.
As long as it's not being amended to avoid liability. Thank you, sir.
Uh-huh, and one more.
Oh, for coercion of other, amended to coerce other members? I'm sorry.
Remember I said the case of Allen versus Gold Reef of West Africa,
Mhm.
that members must exercise their votes bona fide for the benefit of the company as a whole. Which means that when they vote, they must vote independently, not to coerce other members.
Okay.
All right, so
Is the case in our handout? I'd like to. read it.
no, it's not there.
Okay, what is the name of the case again, please? Sorry.
The case is Allen, ALLEN versus Gold Reefs of West Africa Limited.
Okay, thank you.
1900. Still in our time.
Pretty much.
Okay.
Thank you.
You want to do a next question or should I assign that one as homework?
No, you can do another one this way. So we
Okay,
won't get any homework?
Yeah, you all have homework again.
Oh,
Oh, so funny. HPLC wishes to change its articles of association to add a clause which states, quote, any director of the company may be removed from office if all other directors give notice in writing of their desire that the named directors be so removed. I can repeat. HPLC wishes to change its articles of association to add a clause which states, quote, any director of the company may be removed from office if all other directors give notice in writing of their desire that the named directors be so removed, end quote. You are required to explain the procedure for alteration and discuss the difficulties the company might encounter in adding this new clause. Now we know the procedure for alteration.
mm-hmm.
So what are the difficulties the company might encounter in adding this clause? Any director of the company may be removed from office if all the directors give notice in writing of their desire that the named directors be so removed.
I mean, I don't know what's the textbook correct answer, but I would imagine that from I mean, obviously, what's the word? And nobody wants to be removed or released from a particular position. So I think it will cause an issue in regards to someone who had so much insight and information on the company, and eventually that could lead to a reputational risk because of course they know so much information about the company. And I know that's thinking way out there, but that's what I instantly think of in a scenario like that.
Anybody else? No?
It runs the risk of, and again, as Shirella was saying, just from a practical standpoint, it runs the risk of an unfair removal. Let's say for some reason the other directors just don't like it, as
Mhm.
opposed to whatever, as opposed to saying, let's say there are 5 directors, 3 of the 5 or something like that.
Mhm.
That-
But wouldn't that be a breach of contract?
the removal.
Any director of the company may be removed from office if all other directors give notice in writing of their desire that the named directors be so removed.
I don't know. I don't see how. I mean, if the director is deemed not proper and unfit, then
But that's not one of the conditions that they
True.
stated.
true.
This is just based on they're all deciding that they just don't want the person anymore. They didn't give any.
I see what you're saying. There's no particular cause. Is what.
No.
is what-
Normally people have conditions upon which they would either do a removal or termination or
Okay.
fixment. And remember now, whenever you're going to do an alteration, it has to be for the benefit of the company as a whole. So would that alteration benefit the company as a whole with them having that power?
Ms. Archie, but I thought this was a thing. Like I thought the majority can vote to remove a director.
Mm-hmm.
So unusually when it's like that, it's usually for the benefit of the company.
But she was saying
This
it's usually
particular case.
stipulated under certain condition that that
Right.
could happen.
Okay.
Not just that they all agree to remove this
Mhm.
particular director. There has to be certain conditions.
Okay.
Am I correct? Ms.?
Yes. So in the case of Southern Foundries, the appellant company was incorporated in 1926 as a private company and was engaged in the business of iron founders. The respondent, Charlaw, became a director of the company in 1929 under a provision in the articles. In 1933, he became managing director under a separate contract, the appointment to be for 10 years, and containing restraints under which Charlaw agreed that he would not, for a period of 3 years after leaving the employment of the appellant, engage in foundry work within 100 miles of Croydon. In 1935, there was a merger between the appellant company and 10 other concerns, and the group was called Federated Industries. The members of the group agreed that they should make certain alterations in their articles regarding directors. The articles of each company were altered, and in their new form gave Federated Industries power to remove any director of the company, and also stipulated that a managing director should cease to hold office if he ceased to be a director. In 1937, Charlaw was removed from office as a director under the provisions in the articles by an instrument in writing signed by 2 directors and the secretary of Federated Industries. This meant that Charlaw could no longer be managing director of Southern Foundries. And since his contract had still some time to run, he brought this action for wrongful dismissal. The trial judge found for Charlaw and awarded him £12,000 in damages, and the Court of Appeal affirmed that decision. The company now appeals to the House of Lords, held by a majority, that Charlaw's contract as managing director contained an implied term that the article making him a director would not be altered. Since it had been altered, there was a breach of contract and the company was liable for it. Lord Wright took the view that since there was no privity of contract between Charlaw and Federated Industries, it was difficult to see how they could dismiss him. Lord Roma, dissenting, did not think a term against alteration of the articles could be implied and thought that Charlaw took the risk of alteration. So he took the opposite view. Lord Porter lent support in this case to Punt versus Simons and said that a company could not be prevented by injunction from altering its articles, but that the only remedy for an alteration which has caused a breach of contract was damages. So remember what I'm saying, whenever you're dealing with one type of law, when it comes to breaches, especially breach of contract, then you revert to company law. So that's one of the difficulties that they will be facing as a company, whether or not with the alteration of that clause, if they're going to breach any contract by automatically terminating persons in certain positions. Any more comments on that one? Okay, next question. Contrast the rules governing contracts purporting to be made on behalf of a company before it has been incorporated under the Companies Act with those governing contracts made by or on behalf of an incorporated company before it is entitled to do business. Contrast the rules governing contracts purporting to be made on behalf of a company before it has been incorporated under the Companies Act with those governing contracts made by or on behalf of an incorporated company before it is entitled to do business. You want that one for homework?
Why not?
You sure,
Okay.
Sandy? You sure?
Yes, I have another one.
It's like 10 homework I got now.
Right?
And I have another
Oh,
one.
Lord, Miss Archie, you're killing me dead.
No, I am
Miss
not.
Archie, you can't do that to me.
Why?
So is that one gonna
Oh,
be,
don't do that, man. The Lord was.
Hmm?
is that one gonna be the one you read just now? Will that be homework? Or-
Yeah, but I add another one to that one.
Oh, Jesus.
Oh, okay.
And make sure you exercise your brain. This one says the company secretary has in the past been permitted to order office equipment and stationery for the company, but no single transaction has exceeded $500.
Mhm.
Recently, without the knowledge of the directors, she has ordered a computer installation costing $200,000.
Hmm.
The board does not wish to proceed with the purchase, but the supplier is claiming that the company is bound by the contract. And I want you to advise the directors.
That is good.
So that should be a good one, right?
Mm-hmm.
Okay, so that's two more questions. Two more.
You'll email these to us, Ms. Archer?
Yeah. I'll do it right in a few minutes.
Okay.
For true, Ms. Archer?
For true. Right on the same email, right on the same email you got from Miguel.
Ah, Lord.
I'm going to be sending that to you.
Okay.
Class, hold on. Where's my next class is Unit 5. When is the midterm?
Midterm.
After the 28th, eh?
Yes.
Yeah, so you have time. Should I, what the day is?
You'll send the outline for the midterm on the email as well?
I'm trying to see whether I should send the midterm now.
That makes sense. So we could get, more
I
time.
think you said it would cover chapters 1 through 5, so
Yeah, so,
could give us a little head start and then
Mhm.
yeah, so I should send this now because that's due then.
And then next week, whatever questions we have, we can hash out when we meet.
Where, on the midterm?
Yes, ma'am.
No, don't squeeze that in there, on your
Nice
own. Unless there's a typo in here I miss, on your own. So now I have to do is just write your capstone. Which is due for the final exam. Okay, so you want me to send this midterm today?
Yes, ma'am.
Okay, so put here send today. Plus 2 homework questions. Don't forget you get points for these now.
Points for what, our homework?
Yes,
Even if they're not the best?
yes.
Oh, okay.
How much points our homework go towards our final grade?
It depends on how the midterm grades look.
Hmm.
Cause I just trying to figure out if I should just put all my emphasis towards the midterm and call it that, cause these homework killing me.
But what you think the midterm will do?
Well, I rather do the midterm than have to do 4 other stuff by itself.
But I'll put it to you like this. There have been others who would just do the midterm and just do the final. That's it. Then I have some people who would have done the midterm They tried on the homework. Some people might have only done a quarter of it. Some would call me afterwards. They would try it. They would send it in. They'll say they attempted it. They'll try to put some points together. They couldn't like say. They'd send me emails. They really didn't understand it. Can they go through it? And at the end of the day, when they got kids and they were like 67 away from the 70 to pass, they were able to pass. Because
Well,
they
this
made,
ain't a scrapping crew. We scrapping. Let's do that.
yeah, those couple of points sometimes.
Yeah, I really think I scrapping like that.
No, we can do that.
Mm-hmm.
Mm,
Okay. So it's always
Yeah.
good to
All
have a
right.
point kitty that you could throw in. You never
Mhm.
know.
Mm,
What is on about? I don't like this. I don't know what does that mean. Let me tell you the point of the homework besides the points is for you to start to see how
Mm-hmm.
the questions will come
Yeah.
and what's involved. Because there's not a one-word answer. So, but on next class, we could just, if you have a question, a general question, not an actual question, but a general question on one of these, then you can ask for the midterm. And I also gave you a bonus.
Amen.
The post. There's 5 questions. 1 has 4 parts, 2 has 3 parts. 3 has 1 question, 4 has 3 parts, 5 has 2 parts, and then there is a bonus. Okay? No need to be sad. It's not difficult.
Okay, we trust you.
Yeah, it's not hard at all. Yeah. Okay.
Well, I think it was Sharella who said last class, she took a class with you before and you always make sure that your students are well prepared. So
Mm-hmm.
Yes.
we won't agonize just yet.
No, I don't like surprises. Not like that. That's to me, it's not fair. So I won't do that to you. All right. Okay, so when you get it, I'm sure you'll be saying, yes, this is fair. Mm-hmm. All right, so enjoy the rest of your weekend. Look for my email, it's gonna be coming in, bling, bling.
Thank you. We
Thank you
will.
so much.
Have a good weekend, everybody.
Take care.
Thank you.
Enjoy your weekend.
Bye.
Okay, bye.
Sure, I will be emailing you.
Okay, all right.
Okay,
Okay.
Okay.
So
bye.
will I.